recordings and any information contained in them for webcasting and training purposes, and for the purposes of keeping historical records and making those records available to the public. I would ask that you keep yourselves on mute during the proceedings this morning, unless you need to speak at any point. Please be patient with me as I bring you in at the appropriate times. I would request that if you're not the lead spokesperson, if it's okay, if you could turn off your camera just to help manage the number of people that are seen on screen at any one time. If you feel you need to stay on, that's perfectly fine. If at any time you want me to slow down, or you're communicating with your team and you wish that we pause, then please just let me know. If you have to leave in the case of an emergency, please do so, don't hesitate. So the purpose of today's meeting is to discuss the procedural arrangements for the inquiry and associated procedures necessary to consider this case. There will be no discussion on the merits or otherwise of the application or of parties' cases today. An agenda was circulated, which I hope everybody got, for the meeting in the second week of May, and hopefully that will give you time to consider your points and also my current thinking on further procedures before coming here today. I will be keeping a note of our discussions, and we'll circulate a note of the meeting which will include the key decisions as soon as possible, and I hopefully will get that out within the next 7 days, and it will take the form of a procedure notice. The notice will set out all the procedural arrangements that we agree today. As I'm taking notes, I may ask you to slow down when you're speaking, or to ask you to repeat what you've said, just to make sure that I have an accurate note of what is discussed and has been agreed. Finally, as we go through the process, I hope that I accurately pronounce any local place or property names. If not, again, please advise me and I will try my best to get my tongue around some of the names. Before we go on to item 2, are there any questions on any of these matters or points that need to be raised? I'm seeing shakes of head, that's fine. So item 2. It's an introduction of those representing the parties. So if I can ask the lead spokesperson for each party to introduce themselves and anyone else who may be participating today. So firstly, if we can start with the applicants.
Thank you, sir. Good morning. My name is Marcus Trillick. I'm a solicitor of King's Counsel, and I'm instructed by Fraser Gillis, Wright Johnson Mackenzie, who will show his face on screen now. Also joined by Julie Aitken, the Senior Project Manager, and by Charlotte Kenyon, who of SLR Consulting, the EIA lead, if they could just share themselves. Thank you very much, sir.
Thank you very much for that. And for the Council.
Sorry, there's a delay there. Just had to unmute myself. Morning, sir. My name's James Finley, King's Counsel. I'm instructed by Arlene Gibbs from the Council. I'm not going to ask her to expose herself again, although she has. And I'm joined on the public side of the call by Roderick Dull, who is the Planning Officer, and Andrew Daly, who's going to be our Landscape and Visual Impact Consultant.
Okay, thank you for that. And the only other party is yourself, Mr. Kelly.
Good morning, sir. Thank you. Ian Kelly of Ian Kelly Planning Consultancy Limited. I represent, as you know, Mr. and Mrs. Crook, who stay at Ardaki Road in Fort Augustus, adjacent to the access to the site and adjacent to the site itself. Thank you.
Okay, thank you.
I should say my clients are watching on the webcast rather than participating in the meeting.
Okay, that's perfectly fine. That's great. Thanks for letting us know. I don't think there's anybody else on the meeting this morning. No, I'm not seeing anything. So that's all the parties, or the 3 parties that's introduced this morning. Okay, any questions on item 2 before we move on? Okay, item 3. I'm sure this will be familiar with the parties involved, but I will still go through the code of practice and handling of inquiries. As you will be aware, there are no detailed procedural rules for the conduct of inquiries under the Electricity Act. However, the DPA has produced a code of practice which has been modelled on the 2013 Planning Appeal Regulations, and I intend to apply the code of practice in this case. If you haven't seen it, the document is available on the DPA website, and I'll include a link to that in the note of this meeting. Essentially, the code allows for flexible procedures. Each issue that requires a further procedure will be dealt with by the most appropriate method of examination. This could be an inquiry session, a hearing session, or further written submissions. On some issues, sufficient information will have already been submitted, and I will not require further procedures. However, when I write my report to Scottish ministers, I will take into account all of the environmental information submitted by the applicant, together with all the consultation responses and any letters of representation already lodged. Also, the type of procedure being followed, or indeed the absence of any further procedure, is not an indication of the importance of a particular issue. At this point, I would normally briefly explain the difference between a hearing and an inquiry session, but given the participants today, I don't know if that's necessary or they would find that at all helpful. So to speed up the process, I think we all are aware of what a hearing session, an inquiry session, and further written submissions constitute. So are you happy for me just to move on past that point? Okay, that's great. You'll see in the agenda and in the annexes that I've already set out how I think the case should proceed, and we'll discuss that soon. Site visits are also part of our evidence gathering, and I intend to carry out site inspections, and we'll come on to that later onto the agenda. Any questions on this item? Item 4, this is just an opportunity for an update from the applicant if there happens to be any. So I would like to offer the opportunity to the applicant to inform us of whether there are any particular updates to the application that I or party should be aware of, and which may impact on this inquiry.
There are none, sir, and none upcoming.
Okay, thank you for that. I would advise that any changes to national or local energy planning policy since the application was made or the Council's report to its committee can be reflected in the statements for the legal and policy session, depending on the form that takes. Okay, if there's no further comments on that, we'll move on to item 5, and this is just looking at whether there are any additional information required. Additional information in relation to the EIA regulations is often required through an inquiry process, and I'm keen to run through any implications of potential additional information from this case. From my review of the position statements, I'm not aware of any additional information that has been published by the applicant in relation to the application. Can I just confirm that?
Correct.
That's correct.
Also, sir, if I can just amplify that, we have looked at the need to update the cumulative landscape and visual baseline, but remarkably in this case, we do not see the need to do so. All projects in the planning system have been accounted for. Some have changed status since submission, but there are no new projects. And in the view of the applicant, no update to the cumulative baseline is required.
Okay, you've preempted me on my next part, which is fine. That's fine. That saves us time. What I had noted was the council, in I think it was para 2.18 of the report, made reference to the assessment having been produced in August 2023, and that the cumulative picture have changed. What I did note was that there didn't seem to be any additional or new wind farms introduced. It is, as you said, there seems to have been 3 wind farms that have been granted consent, with 1 wind farm proposed and currently pending consideration, and additionally 1 wind farm where the consent had now expired. From my summary reading of the LVIA assessment documents, all these proposals appear to have been included in the visual assessments and in the viewpoint assessments as well. So it was really just to go to the council and just to confirm with the council if that understanding is correct, that it's really just relates to a change of status on some of the proposals. Mr. Finlay?
As far as I'm aware, that is correct. If I receive further information during the course of the call, I'll alert you to it. But my understanding is I'm happy to proceed on that basis at this stage.
Okay, so in terms of requiring any further update, are the council of the view that an update is required, or happy for me to take on board that I can understand that the status of these have changed within the reports? You may have to take advice on that, sorry.
My understanding, unless I'm wrong, is that we're happy for you to proceed as you've suggested and as Mr. Trinick suggested.
Okay, Mr. Trinick.
So if it helps the council to consider the point, the ones that have changed status are Bunloin, Tomkraski, Krateg and Cloik. There are new schemes, but they're more than 35 kilometres away, and we've dismissed them in our own mind from consideration. And there's Clune, Highland Wind Farm, and two with appalling Gaelic names I can't completely pronounce. But they are beyond 35 kilometres, and we've discounted them. So that's the full story.
Okay, Mr. Findlay.
That's helpful. I have no reason to doubt what Mr. Trinick said. Wind farms beyond 35 kilometres aren't going to be of interest anyway. So I'm happy for you to proceed on the basis you've indicated.
Mr. Kelly, do you have any comments to make on that?
I have no reason to dispute what's said. I'm happy you proceed as you suggest, sir. The only thing I would say, I'll raise it and I would have raised it later, is that at some point I would like a hard copy of the visualizations that will be used in evidence. I don't have that just now, but that can be attended to.
I think Mr. Trinick's thumbs up is indicating that that's possible, and I will leave you two of you to organise that offline. That's okay. That's great. Okay, thank you. The only other matter, sorry, before going to that, so that covers that. Yes, the council also indicated in the report some concerns in relation to the cumulative assessment, where there was a level of dispute in relation to the applicant's approach, not according with GLVIA 3 guidance. I'm satisfied that this point can be covered off in any inquiry session or hearing rather than requiring any additional information. Mr. Trinick.
Yes, sir. Or indeed a statement of agreed matters where we can flush it out.
Okay, Mr. Findlay.
That sounds sensible, either in statement of agreed matters or in evidence.
Okay, that's fine. The only other matter in terms of additional information did arise following the issuing of the agenda, where I think I indicated some responses from the applicant in relation to points raised by Mr. Kelly in relation to private water supplies and flooding and to transport and traffic. And the comment that came back from the applicant was for, in order to provide a response to that, some further detail. I think the points raised by Mr. Kelly, and Mr. Kelly, you can keep me right here, was in your initial objection at para 41, where you make reference to the private water supplies, and at para 44, where you make reference to traffic and transport. I think there's, sorry, before going, Mr. Trinick, do you want to just comment, because the matter was raised pre to the meeting by yourself?
Yes, I have the paragraphs in front of me, and perhaps Mr. Kelly could confirm with a nod if I've got the right ones, that paragraph 40 deals with Ardaki Road, paragraph 41 deals with the private water supply, and paragraph 44, and this is of the initial objection, deal with the access issues. What I suggest, sir, if it's all right, we will certainly come back in writing, as you suggest, on these points. If we feel we need more information from Mr. Kelly before doing so, we can approach him direct and get that information.
Yes, Mr. Kelly.
My clients have been gathering more information on these topics, and we had anticipated that you would proceed by way of written submissions with provision for a rebuttal. So it was certainly our intention to make additional, more detailed information available to the applicant and to yourself so that they could respond to it. If you decide you wish that at an earlier stage, then we will look to comply with it. But the current thinking was written submissions and a provision for a rebuttal by the applicants.
Okay, on that basis then, I think we can come on to that when we look at the further written submissions, but I may request the information from Mr. Kelly first and then provide the applicants with the opportunity to comment. That would give a bit more time for submission and a bit more time for comment. Are both parties happy with that approach? That's fine. On that basis, I don't think there's any other additional information that I was aware of that any party has raised any questions about. Is that correct? Okay, I'm seeing nods all round. That's great. Thank you very much for that. That was very helpful. Item 6, basically a provisional assessment of the main issues to be addressed. As I've indicated above, all the written material already submitted by parties will be taken into account, including all of the submitted representations and objections. I would also emphasise that all parties who wish to be involved in an inquiry session should understand that they need to prepare and submit their case in advance to allow the other parties to see what evidence is being presented and to avoid any surprises on the day. Parties may wish to rest on their existing representations, or they may wish to present further evidence, which is fine, if it's provided in advance at the appropriate stage of the process. However, parties are not required to participate in all the inquiry or hearing sessions, nor should they feel they need to do so. The whole process is designed to be fair and open, so everyone has access to the same information on which decisions will be made. While it may not always be necessary, parties should be prepared to take questions on their evidence from the lawyers or representatives of other parties. Having reviewed the submissions, I have set out Appendix 1, and that contains my initial thoughts in regard to proposed inquiry sessions, hearings, and further written submissions. Whether sessions will be held virtually or in person, we can agree later in the agenda, although we may stray into that now too, and if we do so, so be it. As part of the gathering of evidence where relevant, I expect a statement of agreement, which has already been referred to earlier, to be prepared between the applicant, the council and Mr. Kelly where appropriate, setting out the matters where there's agreement. I expect this is probably like to be around the legal and policy context and the landscape and visual assessments and the conditions as we move forward. There may also be other areas of agreement that is for you to consider, but the sooner this can be prepared, the better for myself in focusing down on the matters of debate at the inquiry or at hearings. We will discuss timescales for statements of agreement later. So having said all that, the focus for the discussion today will be on the hearing, inquiry and site visit procedures. Further written submissions will be fleshed out and detailed requests set out in the minute of this meeting. The timescale for the submission and responses to the further written submissions will be the standard 14 days for submission from the issuing of this note as a procedure note and 14 days to respond. Details of that will be set out again in the note of this meeting. I would just like to reiterate that where no further procedure is listed for any topic, this does not indicate that those matters are not of importance. It's simply an indication that I consider that I have sufficient information in order to write my report to the ministers. Finally, the fine detail of the scope of each procedure will be set out in the note of the meeting following the discussion today. So that said, I think we can now move on to looking at Appendix 1, and this is really just looking at whether the procedure proposed is as agreed with parties. So if everybody's got Appendix 1 to hand, which I hope they do, we shall just work through this in turn. So if we can just start with the applicant first, Mr. Trinick.
Thanks, sir. We agree with the hearing for policy. We agree with an inquiry session for landscape and visual impacts. we agree with a hearing session for conditions. We don't think that any other oral process is needed.
Okay, thank you for that. Mr. Finlay for the council.
So we agree a hearing session for legal and policy. The Highland Council's preference is for hearing sessions on landscape and visual, but if your view is inquiry, so be it. In terms of the further written submissions, you've under wildland and aviation lighting required clarification of the council's position on impacts of wildland and aviation. No doubt that's because they're both referred to in the report. I don't know whether I can preempt that by saying that in terms of wildland, it doesn't form part of the council's objection. The report noted Nature Scott's position, but the reason for objection doesn't include wildland. And as far as aviation is concerned, the council considers the proposals acceptable subject to the conditions I think it's suggested.
Okay, sorry, Mr. Finlay.
No, if you require those to be put in writing, obviously they can be, but that's the position on both of those.
Okay, that's very helpful. That's what I was looking for. It was just there were points raised within the committee report that I just wasn't clear that they hadn't been pulled through to objection, but they seemed to raise that. So what I'll do is I'll keep them as further written submissions, but your clarification there, if that's what it is, then that's fine. But just so I've got that properly recorded in writing for my own benefit would be helpful, if that's okay.
Yes, thank you. So, I mean, I should make it absolutely clear in respect to the wildland, the Nature Scott's position was reported as it properly had to be, but it doesn't, and that there are some impacts of wildland. I don't think it's in dispute between the parties, but it doesn't form part of the council's objection. We're not intending to lead evidence on it.
Okay, that's helpful clarification. And can I just check, I may have missed this, but the planning conditions, a hearing's fine for that session for the council?
Yes, sorry, my apologies. Yes, the council and Mr. Trinick's clients are well used to trying to sort conditions, so hopefully if there are conditions still in dispute, they will be very limited.
Okay, I think on the basis of holding the hearing if it's required, but if you get to the point where things can be dealt with in written submissions, then that may be an alternative, but we'll hold the hearing just in case we require it. Okay. Thank you, Mr. Finlay. That's everything? Yes. Okay, thank you. Mr. Kelly.
Thank you, sir. Agree with the hearing session on policy framework. My client's preference for landscape and visual impact is a hearing session, but again, if you wish to have an inquiry, we'll fit in with that. Written submissions on the other aspects, I'm not sure that we will say much on cultural heritage. In relation to natural heritage, we will reference matters relating to ornithology. Planning conditions, I agree, a hearing session. Given the location of my client's house in relation to the development and access, we would want to be very closely involved in the development of the conditions and the review of the conditions. And I think, as we have already said, sir, in relation to items 5 and 6, we will certainly be requesting an accompanied site visit. Otherwise,
okay,
content, sir.
Okay, we can pick up the site visits under that item, but remind me to do that at that point. Okay, I think that's fairly clear on those points. Okay, so looking at participation, item 7, participation in the further procedure. We've got general agreement on sort of process. So I'd like to go through each one and confirm about participation and likely timescale required by each party. We'll also discuss whether a particular procedure should be in person or virtual. So if you wish to comment on that as well, that would be helpful. So we'll just go through the items again. If we can go back to the applicant, Mr. Trinick, in terms of the timescale that you see required for, we've got the legal and policy hearing, the landscape and visual inquiry, and the conditions.
So I think we're looking at a maximum of a 3-day oral process, maybe less. I would see landscape as taking at the most a day and a bit. Policy hearing session never seems to last more than half a day at maximum. And conditions may last very little time at all. It may be down to as little as two days in this case. We would like all oral sessions to be in person, in locality, and we have ideas for venue when we come to that. I think I've dealt with your point, sir.
I think you have, very briefly, but very succinctly. Thank you very much. Mr. Findlay?
I shall be more succinct. I agree with Mr. Trinick. I think it's likely we'll finish within 2 days, but we should keep 3 days set aside just in case we don't.
So 3 days in total for all procedure?
Yeah.
Okay.
I agree with his view as to timing, day and a half, say for landscape and visual policy, less than half a day in conditions if necessary. But okay, it may just stray into the 3rd day.
Okay, and in terms of in person or virtual?
The council's general position is for virtual inquiries, but it is aware that the current practice is to have in-person inquiries.
Okay, thank you for that. And Mr. Kelly?
Generally in agreement with what's been said in relation to timings and process. I think, yes, 2 and a bit days. Preferences for an in-person oral evidence sessions. And I think if you were to allocate 3 days, sir, then I know you want to come back to the site visits, but I think allocating 3 days would allow for an accompanied site visit on the 3rd day. We don't, unless MD else raises issues, we don't anticipate you undertaking extensive walking for the accompanied site visit. It's all localised to my client's premises. Thank you.
Okay, so that's very helpful. Thank you. So what I'm hearing is we're looking at 3 days in total, 1.5 for landscape and visual, and a half day each potentially for policy and conditions if required. I'll just look for nods from everybody. I think as 2 parties are looking in person, I think it's likely to be in person, but I will reflect on that and confirm that in due course. And Mr. Trinick, I think you indicated that you had a potential suitable venue as for that.
Yes, the Lovat in Port Augustus has been used for inquiries before. If that's available, it's got disabled access. It's got all the usual facilities of a hotel, and it's very good.
Okay, thank you very much for that. Are there any other comments on any of that, Mr. Finlay?
Yes, I think the previous Culachy inquiry was at the Lovat Hotel, so I'd confirm that it's an appropriate location.
All right. Okay, that's great. Thank you very much for that. So, moving on to item 8, dates, location, and likely overall duration. We've run ahead of ourselves, but that's fine. So, in terms of the proposed dates for the inquiry, the correspondence that we had prior to the PM with the applicant and the council indicated to me an availability during the week commencing the 27th of October. Is that still the case?
Yeah, yes.
And Mr. Kelly, does that suit you as well?
Yes, sir. It suits me if you have the inquiry sitting Monday, Tuesday, Wednesday, or Tuesday, Wednesday, Thursday. For personal reasons, going on holiday, I don't want to be there on the Friday and have 2 long drives in the same day. I don't think there'll be an issue, sir. But yes, we are available that week.
Okay. What my normal practice would be is to start the inquiry on the Tuesday. That would allow for people to get up during the day on the Monday to the venue and run from the Tuesday onwards. So if all parties agreed that we would commence on the 28th and run through, I'll just get my... and run through the Tuesday, Wednesday, Thursday. That would be the 3 days. Are parties happy with that? Okay, I'm seeing nods all around. So I'm just ticking off the boxes we've already ticked because we've answered some of my points already. So we've got the duration, we've got the dates for the inquiry starting on the Tuesday, so that's all fine. So just for completeness, each party at the inquiry sessions would present their evidence in chief, which would be subject to cross-examination with an opportunity for re-examination. That's an inquiry session. Friendly cross-examination between parties of the side will not be permitted, but questions and clarifications are acceptable, which I'm sure you're all aware of already. In closing this item, I would say that I will make the final decisions on all these, but I think we're in general agreement, and that will be reflected in the note of the meeting, which I say I will issue by next Wednesday. So item 9, proposed site inspection arrangements. I do intend to carry out a wide range of unaccompanied site inspections prior to the commencement of the inquiry session. Given that this towards the end of October, I think I'd prefer to be on site earlier in the year where the weather hopefully is a bit better. So I'd be looking to do some unaccompanied site inspections during September. I intend to visit the general area, but I also intend to visit viewpoints where there have been significant impacts identified, but in particular where there are disputes between parties on certain viewpoints. So that's my general approach. Mr. Kelly, you have sort of raised the question of accompanied site visits. Would you just like to sort of expand on that just now, please?
Thank you, sir. Generally, we are content that you undertake the vast bulk of the site visit work on an unaccompanied basis. At the conclusion of the oral evidence sessions, we would ask for an accompanied site visit to my client, the areas around my client's house, the paths, the fields, and the access route to the wind farm. I anticipate that this accompanied site visit would take you an hour, at absolute maximum an hour and a half, and just to let you see on the ground the issues that are raised by my clients. So that is the total extent of the accompanied site visit that we would seek. Nothing else, sir.
Okay, Mr. Chinnock, any comments on that?
No, quite happy.
Okay, Mr. Finlay.
No comments on that.
Okay, if it's going to take that short period of time, my immediate thought was to look to do it on the Friday, because I'll be up there after the inquiry. But that's where I think you indicated that you might be departing on holiday, Mr. Kelly. So I don't know whether you feel you need to be at the accompanied site visit. The alternative would be for the Monday afternoon before the inquiry starts, just to pick up the time when I'm actually there. If you're, I think did you say you're looking at after the oral sessions as your preference?
Sir, after the oral sessions is the preference, but we'll fit in with your timetable. if you held the site visit on the Friday morning, my clients are more than capable of undertaking the accompanied site visit with you. I would brief them on the rules, sir, so that they knew what to do. I leave it in your hands, and we will fit in our availability to what you want to do.
Okay, can I just check with the applicant? Would you be available on that Friday morning of that week?
Someone will be available.
Okay, and for the council?
Yes, if I'm not sure necessarily someone for the council will be in attendance, but that's a matter we'll revert on. But because it's not a matter that particularly concerns the council, and as long as somebody from, if you like, both sides of the argument are present, then it doesn't. The council doesn't need to be present.
Okay. We'll just seek confirmation of attendance in the note of the meeting so we can pick that up. Are you happy that that covers your question, Mr. Kelly, in terms of accompanied site visits?
Yes, sir, I'm perfectly happy. I'm just looking at the clock. Can I just take this point to interrupt and say that I'm expecting a delivery of documents, so I may have to nip away from the meeting for about 30 seconds to answer the door sometime around 11 o'clock or after 11 o'clock.
That's okay. I'm sure we can pause for a moment or two. I think everybody welcome that. Any questions on the site visit from any of the parties then? We're happy on that basis. Okay, thank you. Item 10 is arrangements for document management for all parties. The arrangements for the submission and management of documents have been revised, and a new guidance note 23A, which adds to guidance note 23, is or should be available on the DPA website soon. So it changes the timescales for the documents, but still more or less follows the same sort of process, but it splits the documents into what's called foundation documents and supporting documents, and it's really trying to avoid any late submission of documents so that everything is submitted early in the process and a list is finalised as soon as possible. Rather than me going through explain this to you verbally, I will hopefully be in a position to attach the guidance note, which sets out in detail what the documents management process will be. So I'll do that. The emphasis will be again on the applicant taking the lead to put that together. And if the applicant can identify a contact person to speak to the case officer and to take that forward with all parties feeding in. Given there's only 3 parties here, I think that shouldn't be a too complicated task in this instance. So that new guidance will come out to you there as soon as I can get that to you. Is there any questions on the documents? Okay.
No, so we're already trialling the new system in another inquiry in Aberdeenshire, Mr. Findlay and I, so we're familiar with the new process. Right, so you should be experts by the time you get to this one, hopefully. Oh, yes. That's very good. Thank you. Item 11 is the timetable for documents, written submissions, statements and recognitions, including the conditions. Again, this will be attached to the note of the meeting, but I will just go through this hopefully before Mr. Kelly's doorbell rings for the delivery. But if not, we will pause. So based on the anticipated date of the inquiry starting as of the 28th of October, which we have agreed, the following is my sort of timescale as we progress. So the 11th of June, I intend to have the note of the pre-examination meeting issued. At that point, further written submissions will commence. And also at that point, the foundation document list, which is one of the new terms for documents, populated with the application documents, will be issued to the applicant by the case officer. So that's the 11th of June. On the 18th of June, all parties should confirm participation as relevant to the inquiry and hearing sessions within 7 days of the note of the meeting being issued. So that's the 18th of June. That should also include the names of any witnesses appearing.
25th of June, that will be the deadline for parties to submit the requested further written submissions information, as will be set out in the note of the meeting. By the 9th of July, the deadline for comments on the further written submissions, where relevant, will be submitted. Also on the 9th of July, we'll be looking for the first draft set of conditions. And also on the 9th of July, that's when the applicant will return the foundation document list to the case officer. And at that point, the foundation document list would be fixed, and that should contain all the main documents being referred to and shouldn't be added to beyond that stage. Okay, so moving on to the 23rd of July, that's when I'll be looking for statements of agreement to be submitted. We've already indicated that there's no additional information, so that's fine. And also on the 23rd of July, comments on the first draft set of conditions to be submitted. Moving on to the month of August, the 6th of August, that's when I'd be looking for inquiry and hearing statements to be submitted. The statements should provide the full details of the case that we put forward and specify the witnesses that will speak and to what subjects. The statements should include hyperlinks to the relevant foundation documents and also, importantly, list all other supporting documents that will be referred to or relied on in evidence. Also, all supporting documents, including any inquiry reports, must be submitted with the hearing and or inquiry statements. And also on the 6th of August, that's when I'll be looking for the final draft set of conditions to be submitted, with statement from the applicant highlighting any areas of disagreement or alternative positions. Moving into September, the applicants will finalise the documents list. That's primarily the supporting documents to be used, and the completed hyperlink documents will also, but that's all be set out in the guidance notes. So 22nd of September is for the final document list. Given there's some school holidays in October, I would be looking at preconditions on the 6th of October. It just gives an extra week for parties to see that in case there's any kind of holiday arrangements around that time, with hearing agendas and inquiry timetable issued on the 13th of October. At that point, the case officer will also circulate the final document list. Then on the 28th of October, our inquiry and hearing sessions will commence, as we've agreed above. Closing submissions will be agreed at the end of the inquiry session, but probably looking at 14 days for the parties and then another 14 days for the applicant to submit. As you'll probably all be familiar with, these should include a case summary, which a template will be provided, and that's now included within my report on those matters. So I've thrown quite a lot of dates at you there and information. Any comments or concerns? We'll start with Mr. Trinick.
No, sir, all very clear, and thank you.
Mr. Finlay?
Nothing at this stage, so if there is anything, we'll revert to you, but that all seems very sensible.
Okay, thank you. Mr. Kelly?
I'll come back to you, sir, when I see the dates set out in your note, but just as you were going through there, I was thinking that you're looking for inquiry reports and hearing statements basically 2.5 months before the inquiry starts. I thought that could go forward in time to nearer when the inquiry dates are, but I'll look at the dates as you set them out in writing, sir, and come back to you with any comments.
Okay. You're all aware of the format of inquiry statements, hearing statements, precognitions, and inquiry reports. So rather than read through all of that, I'm assuming that you're familiar enough that you don't need me to give you the detail of each one. I will have in the note of the meeting just details on that. So item 12, any comments on that at all? I think we're okay. Item 12, closing submissions and templates for summaries of case. As I said, closing submissions will be made after the close of the inquiry period. We're looking at, as I said, 14 days for parties and then another 14 days for the applicant, which is the standard approach. Again, case summaries to be included within those. So moving on to item 13, which is just the miscellaneous. The DPA contact will be the Claire Seidel, who is the DPA case officer and will be your main contact during the process. Claire will liaise with you as necessary and ensure documents are circulated or made available on the DPA website as required. Full contact details will be provided in note of this meeting, but I think you've already all been in contact with Claire prior to the PEM. So the note of this meeting will set out what was agreed today and come to a final conclusion on the procedures required. It should be treated as if it's a formal procedure notice and will be a key reference for all parties. Just in terms of the process under item 14, on the matter of the daily programme, again, we would look to start at 10 AM on the first day on an in-person inquiry, and then at 9:30 AM thereafter, if we're still going at that point. Looking to finish at 4:30 PM with an hour for lunch. It would be intended, if possible, that the inquiry hearings be webcast when they're in person, but that will be down to whether the resources. I think Mr. Kelly's doorbell has rung. If we're happy, we're almost towards the end, so if we're happy to pause for 30 seconds, that would be fine. Mr. Kelly's now returned, hopefully had the delivery. Any virtual procedure would also be webcast to watch live over the internet, and we would intend to start visual procedures at 10 AM and finish around 4 PM with a shorter period for lunch if that's the case. Importantly, if any party is considering making legal submissions that could affect the running of a hearing or inquiry session, please lodge them as soon as possible and do not wait until the start of the inquiry or hearing. Delaying any legal submissions is contrary to the spirit of prior disclosure, wasteful of expensive inquiry time and unfair on other parties. I'll just ask the question now, but are any parties expecting any legal submissions at this point?
No.
I'm seeing lots of heads. Okay, thank you for that. Do you have any other matters that you wish to raise concerning the running of the inquiry or any of the points that we've covered today? Mr. Trinick.
Only to put on record that I haven't heard anybody suggest a community hearing session in this case. Looking at Mr. Kelly, who might know better than me, I'm not sure there's a need for one.
Sir, at an earlier stage, the Community Council took an active interest in the case, but they seem to have fallen back, and I'm not aware of any requests for an evening community hearing session.
Okay, I would confirm what Mr. Kelly has said, that we, as I say, have been in touch with the Community Councils. Only one indicated interest, but have decided not to participate today further. So I don't see any basis on which to hold a community hearing for the particular proposal. Anybody else? Any other questions? Mr. Kelly?
Just one point, sir, to alert you. I'll discuss this with Claire and with Wright Johnson Mackenzie. Part of my client's evidence will include a film video, so I will discuss with parties the best and most secure way of circulating that to the applicant and to the council and to yourself, but just to make you aware that there will be film evidence coming forward. That's all.
Could I just check on what particular subject matter, Mr. Kelly?
On the flood risk and the water management around my client's property.
Thank you for that. Okay, Mr. Finlay, do you have, yes?
Yes, sir. Just to confirm, on the cumulative matters, the position is as I indicated. We're happy with the position as you and Mr. Trinick jointly set it out.
Okay, that's very helpful. Thank you very much for that. Okay. Is there anything I have missed in this morning? We've gone through that fairly quickly. I just want to make sure that there's nothing that I've missed or anything that anybody wishes to pick up. As I say, once the note of the meeting comes out, if there's any comments, obviously that can be raised as we progress through the inquiry process. Okay, if nobody else has any other comments, I will now proceed to finalise the note of this meeting and plan to issue it, as I said, within the 7 days, and that will set out all the dates of the proceedings from that point. It just takes me to thank you all very much for your participation today, for what has been a very quick and smooth running pre-inquiry meeting, and I look forward to seeing you all at a later date. And on that, the meeting is now closed. Thank you all very much.
Thank you, sir.
Thanks,
Thank you,
Mr.
sir.
Thank you.
Thank you.
Thank you.